So the first provision I'm going to go over today is Rule 5.1-1 from the BC Code. It talks about advocacy and when acting as an advocate. And I think we've covered this before in other contests, but it speaks to your obligation to represent the client resolutely and honorably within the limits of the law, within legal limits. Obviously, treating a court or tribunal with courtesy, respect, fairness, and candor, openness. So in the criminal law context, in particular, all of these principles are enhanced to some degree. Certainly, in adversarial proceedings, you always have a duty to raise every issue, but to fearlessly raise every issue, advance every argument, ask every question, no matter however distasteful, applies even more in the criminal defense context and arguably in the prosecutorial context as well. One of the exceptions here falls under the requirements for a lawyer's function as advocate, an advocacy to be partisan and openly and necessarily partisan. And of course, that still applies for criminal defense lawyers. However, as a prosecutor, a Crown prosecutor, this does not apply. And certainly there are legal limitations and rules that apply to Crown prosecutors that don't apply to other types of lawyers. Partisanship is one of them. So the need to be nonpartisan is something that applies to a Crown prosecutor that doesn't apply to other types of lawyers. This rule also falls under that general category of refraining from expressing your own personal opinion to the court or the tribunal, or even to the jury in most instances. That obviously would, fall under the duty, and particularly enhanced duty of Crown prosecutors to act impartially and be seen to be nonpartisan and not letting their own emotions interfere with their expressions of the case to the court. So in particular for defense counsel, there is an expressive commentary here, or certainly opinion, that it's the lawyer's duty to protect the client as far as possible from being convicted. Obviously, that takes into account the sufficient legal evidence, usually beyond a reasonable doubt, to support a conviction for an offense. But it also talks about, notwithstanding the lawyer's private opinion on credibility or the merits, a lawyer may properly rely on any evidence or any defenses. And it specifically says, including so-called technicalities. Okay, so this refers to those types of legal technicalities. Obviously, they can't be false or fraudulent ones, but anything that is legal, and even if you might define as a technicality, like, for example, a breathalyzer test that wasn't performed to technical specifications, or perhaps an investigation that was technically flawed, those are properly relied upon in criminal defense work. In fact, they're quite often essential for criminal defense work in terms of obtaining exonerations for those charged with particular crimes. So on the inverse of this is that admissions that your client may make to you impose strict limitations on the conduct of the defense of that client. So as a criminal defense lawyer in particular, it's important to tell your client that they should be aware that anything they tell you may actually very well limit the conduct of their defense or how you conduct it. For example, if your client admits to you, you're the defense lawyer, and they admit to you factual and mental elements necessary to constitute the offense. For example, they tell you the mens rea, they tell you the actus rea of an offense, and essentially you think that they're true, that what they're telling you is true and voluntary. That will limit your ability to conduct a defense of their case. You can still obviously take objection to jurisdiction of the court. Technical objections quite often are still appropriate, the form of the indictment, admissibility or sufficiency of evidence, but it will limit your ability to suggest that some other person committed the offense or call any evidence that by reason of the admissions to you, the lawyer believes to be false. So when they're telling you something like that and you believe it to be true, it can limit your conduct of the case. One of the important ways it can limit it is when your client, if you're a defense lawyer, tells you something admitting to, let's say, mens rea, actus rea, an offense, and you think they're being truthful and voluntary in telling you this, it can limit your ability to set up what's called an affirmative case, an alternative case, in terms of, like, say, calling evidence in support of an alibi intended to show that the accused could not have done something like that or someone else had done it. And it can also limit a criminal defense lawyer's ability to attack the evidence for the prosecution. So moving on to provision 5.1-2.1, it talks about incriminating physical evidence. So this is the provision that deals with you're not counseling or participating in concealing, destroying, or altering incriminating physical evidence, because that would constitute, if it could constitute obstruction or attempt to obstruct course of justice. In the criminal context, as we've already touched on in a couple of cases that we've looked at earlier on in the course and other contexts, very, very important. So the way evidence has been interpreted in this rule includes documents, electronic information, objects or substances relevant to a crime. It does not include documents or communications that are subject to solicitor-client privilege. It does not apply where a lawyer is in possession of evidence tending to establish innocence of a client, such as if you have evidence relevant to an alibi. But it does call on you to exercise what's called prudent judgment in determining whether such evidence is wholly exculpatory or exonerates your client completely, and therefore falls outside the application of that rule. If you're dealing with evidence that is somewhat murky, it could expose you actually, and you withhold it or obstruct it and don't reveal it, then it may result in a breach of the rule, and it could potentially expose a criminal defense lawyer to criminal charges in some rare cases. This is the rule that it also has been elaborated on, that a lawyer is never required to take possession of illegal things, which could constitute an offense and require that the client obtain new counsel or could disadvantage your client in other ways. It also specifies that you're never required to take or keep possession of incriminating physical evidence or to think carefully before accept the implications of accepting incriminating physical evidence. Generally, as the commentaries say this too, before you accept any evidence that could be potentially incriminating for your client, talk to a senior criminal counsel if you're in a large firm, talk to a friend or a lawyer who practices criminal law who may have more experience in the area if you don't, or contact the Law Society and talk to a practice advisor before agreeing to take possession of that type of evidence. If you have that type of evidence already in your possession, there's a number of options that it outlines for you in the commentaries to this rule, such as delivering the evidence to law enforcement authorities or Crown prosecution, either directly or anonymously, or to the court or tribunal in the relevant proceeding, or disclosing the existence of the evidence to the prosecution, and if necessary, preparing to argue before the court the appropriate uses of that evidence or admissibility of it, or returning the evidence to its source, providing doing so will not cause the evidence to be concealed or destroyed or altered in any other way. So, as you can gather, this calls for kind of balancing that duty of loyalty you owe to your client that we talked about earlier, and confidentiality, concepts we already talked about in the course. You owe those to your client. And of course, duties owed to what's determined to be the administration of justice. So we've seen that this is already a difficult balancing act. So if you decide to disclose information that's been delivered to you, you have to do it in a way that protects client confidentiality and preserves solicitor-client privilege. One of the things under this rule as well is that you don't have any obligation to assist authorities as a criminal defense lawyer in gathering physical evidence of a crime, but you can't act or advise anyone to hinder an investigation or a prosecution as well. Finally, you must never take possession of an item which is inherently illegal, something like stolen property, unless there's specific exception or dispensation afforded legally. There's something called the innocent possession exception that allows someone to take possession of that type of an item that's illegal just for the sole purpose of properly turning it over to the police or the prosecution. So the next provision of the BC Code I wanted to go over relates specifically to your duty when acting as a prosecutor. So in that role, there's a little bit of different consideration here, where it says you must act for the public and the administration of justice resolutely and honorably within law's limits, while treating, of course, the court with candor, fairness, courtesy, and respect. So it's sort of a blending of some of the traditional requirements with treating the court, as well as a wider responsibility of acting for the public. This is the code provision that talks about your dual role, or really, not really dual role, but one role with two branches on it. One as a lawyer and one as a prosecutor, and where your primary duty in that regard is not to convict as a Crown prosecutor, but to see that justice is done through a fair process, usually consisting of a fair legal trial. It explicitly acknowledges that your role as a prosecutor is a public function that involves exercise of discretion and power. What that means is that you have discretion in what in how you approach your job. So you have to approach your job fairly and dispassionately, is what some of the commentaries have said to this rule. Some of the examples of how that conduct should consist of is not doing anything that could prevent an accused from being represented by a lawyer or communicating with their lawyer. Things like requirements for timely disclosure to defense counsel, or more importantly, in some instances, directly to an unrepresented accused of all relevant and known facts and witnesses tending to show guilt or innocence. So this is a sort of crystallization of the principle and of the role of the prosecutor as having a public interest beyond or in addition to the interest of them as a lawyer. So the last provisions I wanted to look at from the BC Code deal with agreements on guilty pleas, and there's a 5.1-7 and 5.1-8. They relate to instances where either before a charge is made against an individual or any time after a charge has been entered, the defense lawyer or for an accused or potential accused has the option of discussing with the Crown prosecutor the possible disposition of the case, unless, and this is of course, assuming the client agrees to it, unless the client instructs otherwise. So the elements here are there's certain subcategories about when a lawyer for an accused or potential accused may enter an agreement with the prosecutor about a guilty plea. And there's elements in the code, and then I'll just briefly go over some of the principles for the federal prosecution service. In the code, it says that a lawyer for an accused or potential accused has the option to enter in an agreement with the prosecutor relating to a guilty plea only after certain conditions have been satisfied. So there has to be sort of like at least some form of investigation by the defense counsel. The lawyer would have to advise their client about the prospects for an acquittal or finding of guilt. They'd have to advise their client of the implications and possible consequences of pleading guilty, particularly the prospects for their sentencing, the sentencing authority discretion of the court, including the fact that the court is not bound by any agreement about a guilty plea. There may be sentencing guidelines in place that a judge may or may not follow, but as a defense counsel, it's your obligation to tell your client that there's always a risk that a judge may depart from that. The client also would have to be voluntarily prepared to admit the necessary factual and mental elements of the offense that they were charged with. And also they would have to instruct the lawyer to enter into an agreement as to a guilty plea. Okay, so it's not something you as a defense counsel can enter into independently. Obviously, your client ultimately has to give the go-ahead for you to conduct those negotiations, and to and ultimately they have to be willing to enter into an agreement about it, relating to it. Now, the commentaries on this particular rule are exceedingly brief. There's only one small comment on it, and it deals with the issue of expediency and the public interest. And it says that generally the public interest and proper administration of justice shouldn't be sacrificed in the interest of expediency. What that means is that although agreements such as this are very common at place in today's world, as you probably know, because of the backlog in the court system and the backlog and actually going to trial, and also the uncertainties sometimes for both prosecutors and defense counsel about what will happen after a trial, that these types of agreements are fairly common. However, there is a general principle that simply because they are useful, because they could speed a matter along and they're expedient, that interest in expediency shouldn't sacrifice the public interest in the proper administration of justice. Now, what does that mean? That means that these types of agreements should only be reached into in principle or in theory if they serve that administration of justice and they're in the public interest. So, for example, from the public interest side for the Crown prosecutor, in terms of the government or society at large or the public, they shouldn't enter into agreements, for example, which offer particularly lenient sentences when perhaps a more stringent sentence for an offense should be awarded. And neither should defense counsel agree to an agreement on a guilty plea if their client would be sentenced more severely than otherwise, they would ordinarily or reasonably have gotten had they gotten to trial. Of course, there's a lot of leeway within those general principles, and that's why these agreements are fairly common. So now I'm just going to briefly go over some of the sort of guidelines that were developed here for public prosecution service in Canada, because basically they talk quite a bit about resolution discussions between Crown and Defense Counsel. Basically, these are encouraged. They're intended to lead to narrowing of trial issues, and that might avoid litigation altogether. What the guidelines and federal guidelines for Crown prosecutors say is that they're actually an essential part of the criminal justice system in Canada. Majority of cases never go to trial, so they're resolved by way of a guilty plea to the charges that have been laid, or to a guilty plea to a lesser offense in many instances. So the way this works is there are discussions between Crown and Defense Counsel. You discuss the evidence, any possible defenses, constitutional issues, including particular charter issues, and other issues or matters in that specific case regarding the likelihood of a conviction. So those are called resolution discussions. At least they're in the Crown Prosecutor's Office. That's how we generally refer to them. They're not defined in the Criminal Code. They embrace sort of a variety of practices than just simply pleading guilt, an agreement on a guilty plea. They can also involve how a case may proceed, what an appropriate sentence might be. Sometimes they deal with what the facts of the offense are for the purposes of a guilty plea. And sometimes if a case is also to go to trial, how the issues might be narrowed a little bit so that in the interests of both parties, the trial could be expedited. So Crown Counsel are very much encouraged to initiate resolution discussions. Prosecutors generally do that in a way of presenting a joint submission as to the exact sentence. And what that will mean will be an agreement for a guilty plea will include the length of incarceration, the amount of restitution order, amount of any fine, and only when, in terms of prosecutors at least, when they're satisfied that the joint submission won't bring the administration of justice into disrepute and would they otherwise not be contrary to the public interest, should you go ahead with that? So those are the general guidelines for prosecutors. In terms of how judges deal with them, there are generally guidelines that they should reject a joint submission on a sentence only. If it's so, there's a general statement from a case law that if it's markedly out of line with the expectations of reasonable persons aware of the circumstances of a case, that they would view it as a breakdown in the proper functioning of the criminal justice system. What this means is that if you have a joint submission on a sentence which is essentially ridiculous and completely out of line, I'll take a really extreme, ludicrous example, a 3-month probation sentence for second-degree murder, for example. Something like that would never fly as a joint submission. So the joint submission is part of this agreement on the guilty plea, and in it, the trial judge is sort of informed of the circumstances of the case. They're outlined any benefits obtained by the Crown in the guilty plea, also any concessions by the accused in pleading guilty. So the general principle here, again, from case law, the greater the benefits obtained by the Crown and the more concessions made by the accused, the more likely it is that the trial judge should accept the joint submission, even though it may appear to be unduly lenient in some cases. So trial judges only depart rarely from joint submissions, but they do. They have discretion to do so. But counsel have to ensure that they justify their position on the facts of the case as presented in court. They provide a full description of relevant facts so that the judge has a proper basis to determine whether to accept the joint submission and the agreement on the guilty plea. A few final things or notes for Crown prosecutors here. They should also be aware of the rights of victims. There's a Canadian Victims' Bill of Rights that has been passed in recent years. Victims of crime have general and specific rights regarding restitution. They require certain positive actions in many cases from Crown prosecutors. So those are some instances that you have to keep in mind too in agreements on a guilty plea. And resolution discussions vary very much from jurisdiction to jurisdiction. But in the federal arena, the underlying guiding principles that I just described are pretty much the same. They talk about openness, fairness, communication with victims, dealing with unrepresented accused, procedural discussions, sentence discussions, narrowing the trial issues, and agreements as to the facts of the offense. All of these consist on the agreement